John, how you doing?
Doing good, my friend.
Good. Great. Great. Well, uh, thanks for doing this today. You ready to roll?
We are. Let's rock and roll.
All right, ladies and gentlemen. So, folks, we're going to do our third presentation now. This is, I'd like to introduce my friend, John Rahoy. John is an experienced trial lawyer with a successful record of defending clients in difficult jurisdictions. John has tried more than 70 jury trials diverted, including many in the circuit court. I'm going to read this slow, John. Don't mind me. I'm enjoying this picture.
I don't like this at all.
Excuse me, I'm talking. In the circuit court of the city of St. Louis, one of the most challenging plaintiff venues in the nation, John has been recognized by his peers for inclusion of the best lawyers in America, former director of Federation Defense and Corporate Counsel, and a 1986 graduate of Parkway South High School. Hi, John.
Hello. Call me Dr. Denham.
Yes, sir. Now, does that coat? I know you. Does that coat still fit? Is this 2021 Christmas? When is this?
I'm pretty sure, given the hair, this was probably junior year of high school, so probably 85 when you were a senior at South. I can't believe you don't remember me wearing this.
Yes. Well, we both moved a lot of different places since then. So, folks, John has always been a friend for a long time. He's just a really great defense lawyer. So I'm excited to do this with you, John. Let's get into it.
Yep.
This is our roadmap. John and I were originally going to talk about tort reform. No tort reform happened this legislative session. So John and I have pivoted a little bit. We're going to talk about trial strategies, voir dire and opening, billed versus paid, what you can and can't say in closing, experts in Daubert, interpleader and insurance company tactics, bad faith, and stacking if we get to it all. And we'll just go. Let's keep going. Hey, John, question for you. Can the defense lawyer admit liability in opening, get credit with the jury, and get away with it?
I would say no. I think any plaintiff's attorney worth their weight would shove it up our proverbial hindquarters. Why would they? Because you wait till the last minute to admit fault, admit liability, and you're doing it at court. It just opens the door, quite candidly, for the plaintiff's attorney to say, you know what, where have they been for the last 2 years? Look how badly injured my client has been. And now they're just admitting liability and they only want to talk about damages now. I think it's a horrible idea. I think from a defense standpoint, you have to really analyze the case. And if it's one that you know is complete liability, sometimes I think you just have to admit fault. I think you gain prestige with the jury by saying, ladies and gentlemen, we admitted liability a long time ago. We admitted fault a long time ago. This is about damages. We do not believe the damages are what plaintiff is are equal to what plaintiff is asking for, et cetera. You gain cachet with them. So the long story, I gave you the long version, but the answer is
John, how often are you admitting liability in a trial? You say, do you think 10% of the time?
In trial or prior to?
Well, in cases you've actually tried, you think 10% of the time?
Yeah, maybe once, twice, 3 times. I've got one now that will be going to trial, and I've already in pleadings admitted liability. The issue is really, is plaintiff going to have 2 significant back surgeries because of the incident? There's no getting around it. My client's completely at fault. So I suspect, now here's the counter to that. Let me ask you a question, Gary. If someone admits fault early on, how strong of a liability case do you put on in your trial?
Well, and John, you asked, you answered when you said at trial or before trial, and I think you've already said a good defense lawyer admits it before trial. And I think you would say probably in an amended answer, probably in an interrogatory answer where you're coming clean and not giving me ammo against you that it's some late deal to try to gain false favor with the jury. And now to answer your question, I'll tell you, it really takes the wind out of my sails, because you're changing all my great damage pictures, all my a lot of the rule. I like to talk about rule violations and safety and warnings and time. And that's the things that juries care about if you get into it. I mean, because they want to protect themselves and their families, right? Because the next time they drive down the road from the bad trucking company or the bad landowner or whatever. But then what happens is you focus the case on, just to use your latest example, on causation, and that's kind of a boring thing. And you can get some good docs, and why should they put 2 future back surgeries on this hit when the person had 20 years of back problems before, type of thing, right?
I agree with that. And I think just as an attorney admitting fault through a pleading or answer to interrogatory garners favor with a jury, I think a plaintiff's attorney loses favor with a jury if they can try a case in a day to a day and a half on damages, but they want to make it a 3-day trial on liability and getting in all that stuff. I don't think it helps their case for the most part. Now, clearly, there are cases where you have to do it. You have catastrophic injuries. I would say a plaintiff's attorney would be wise to still try the case, the full case, right? Because some of those damage photographs will impact the jury's opinion as to whether or not the impact or the incident could have caused the surgery. So it's not, just like everything else in our practice, it's not black and white, it's gray, and there are exceptions.
And there's no cookie cutter. You got to take each case as it comes. You think that these things are the same, but every case is different. And you can't make these, the way John and I are talking, this is not a decision to be made the week before trial. So if he's admitting liability, I'm already thinking, well, do I need a biomechanical guy? When I'm taking my doctor's depots, do I need to talk about force of impact to be a causative factor? How can I get in some of my good stuff that the jury's that's going to be good for me in different ways? Can I couch it or put it under causation? Can I do it other ways? What other experts do I need? But there is some law that says if John admits liability, I can still not put on my liability case.
Absolutely.
However, you got to step, just because I can, why should I? Because the jury has to have a reason to be there. And John hit the nail on the head. Why be there for 3 days when you could have done this in a day and a half and they could be home with their family? Because that's what he's going to say.
That's exactly right.
John, what should we do? Number 2, can I put in medical expenses and prevent you from putting in medical expense? Can I not put in medical expenses and prevent you from doing it?
Case law says if you go on pain and suffering, I'm SOL, as they say. And I have made every effort.
Is that statute of limitations?
Yes, except probably another version. But no, in all seriousness, I've tried every way I can to try and get that in. It just doesn't come in. You have numerous court opinions that prevent it. And now, I will be candid with you. I think it is improper just because you choose to go on pain and suffering. I believe and will continue to believe that plaintiff's evidence, medical bills are evidence of the damage, how bad the person was injured. And I know many plaintiff's attorneys listening to me right now will go, "You're full of crap, Rahoy," but it's just how I feel. But the present state of the law, it's not coming in. We all know that.
So John, you want to talk a little bit about, what other one of these, can we jump to voir dire?
Yeah.
Great. So John, let me, hold on. I got to go back now. Hold on. John, talk to me a little bit about voir dire and what you try to accomplish in voir dire.
I don't know if I'm different because I don't get to watch enough trials, obviously, but my strategy on voir dire, I've gotten further away from trying to sell my case, like we all try and do, and, get facts in here and there. Um, what I focus on now is really requiring the jury to follow the jury instructions.
And that's the first point that you added here.
Yes, because to me, if you do not get, and this is on the defense side, right? I mean, if you do not get the jury to understand the jury instructions, know exactly what they say, and people who have tried cases with me know this is no secret. I tell the jury all the time, and occasionally the jury instructions I will use in voir dire to say, here's what it's going to say. You do not get to consider sympathy. I don't just ask the question. I make them read through the instruction with me. You're not going to find the word sympathy, empathy, any of those things. And then I probe really hard, not just to say, can you follow the jury instruction? I really dig down and say, you understand that's your duty. And you understand if you don't follow your duty, you're not giving me a fair chance. You're not, and I do some other things, strategies that I'm not going to give 100% away, but I really think for the defense, it's important for us to have them focus on jury instructions. For example, reasonable care. Okay. Reasonable care. I represent, some big companies, and a lot of juries will think that reasonable care standard only applies to the plaintiff, that my corporate entities have a higher degree of care. So I will bring out and show them the reasonable care standard and show that it applies to both. I get commitments on that, not commitments to side with me, but commitments to, will they follow that jury instruction? That's just an example of what I do and focus on the jury instructions to get the jury's mindset right.
Can I give you an example of what I do? Is one of the things I do with instructions is, I think where the rubber hits the road for jurors is giving pain and suffering damages. And I try, and if I'm hamstringed on the time that I get to spend with in voir dire, that's what I want to focus on. And what I do is I say, listen, this instruction says it's more likely than not. It's 51%. I know you love it when I do that, John, when I go like this, like 17 times in voir dire and I say, if you're, because people don't know how to say they have a hard time giving pain and suffering damage. It's hard for them to say. They don't want to say they're conservative, and because maybe they're not. And so what I sometimes successfully do is tie it into the burden of proof, and I say, or would you want more proof? Yeah, I do. I want more proof. So what do you want? 75? I get people all the time. I want 75 or 80%. So it would be hard for you to award pain and suffering damage for 51%. So that's an example. John hammers home the instructions on the defense side, but remember on the plaintiff side, you want to do it too, because there's a lot of good instructions for you, and you want to use that burden of proof, and you want to use 401 with the, whatever the damages that were caused by that. So that's an example. John, go through what else do you want to pick out of this voir dire slide? I'll turn it over to you, sir.
Yeah, let me run through some. Look, I'm going to be candid. I don't see it so much on the defense side, but I do see it with plaintiffs' attorneys about being authentic. If I go up and try a case against Gary will always come across authentic. Why? Because he doesn't pander. Not only does he not pander, his inflection of his voice, his mannerisms don't lead to pandering. In voir dire, you have to come across, as well as an opening, as authentic. And if you have weak issues in your case, you have to be candid with the jury about those. How does that make you feel if this evidence were to come in? If you were to consider this, you got to get your bad crap out of the way, period, with voir dire. But again, I find that attorneys do not use voir dire to really get to the heart and soul of the jurors. I will give you an example, and Gary knows this. I had a depressive episode years and years ago, and I was trying a case where the woman had a long history of mental illness. And Gary will probably agree with this. You can get a feel whether the jury panel is coming clean with. And I didn't think they were. And I finally said, listen, I had a depressive episode. I had to get on medication. I had to seek therapy. I'm not doing this to tear plaintiff down. I'm doing this because it's part of the evidence and I have to be able to defend it. How many of you would feel that I should not use it? After kind of, tearing a wound open, the jury actually, I had 5 or 6 that got stricken for cause because I was being honest and they felt comfortable in that space to talk to me. So you need, as an attorney, to be able to read the veneer panel and say, are they shooting me straight? And how can I come up with answers and potential jurors that won't hold bad evidence against me? I also think that,
Hey, John, let me add, it's really important. He said, read the room or read the panel. The worst thing you could do is have a juror open up and say something and you turn down and you read your next question like you don't care. And I've seen so many lawyers do that. You got to read the room. You got to pick it up. And I've had that too. I picked a jury in a suicide case, sad case. And people don't want to talk about that tough stuff, and they don't want to talk about whether people are lying and some of these other things and why would you not get to the meat and potatoes of the case in voir dire? Why would you not do that? What else are you going to talk about? Right. So get to those and try to get to it and read the room, and then they'll feed off of each other. And as soon as you start bringing one person and striking, like John said, of course he got 5 because he broke through and got to real people. I find that with the pain and suffering and the burden of proof thing too. Yeah. And people are like, you know what? I'm kind of like that. Thank you. Because it's important. And you tell them, listen, you may not be the perfect juror for every case. This may not be the case for you.
that's right.
John, what else you want to highlight out of this voir dire?
Just a couple quick things. I do ask jurors, and this is approved, and courts allow it because you're never asking for a commitment. But I do ask jurors, getting back to kind of some specific facts, if the evidence shows this, would you consider that in your deliberations? Because I have had a situation, and I don't even know if it's impactful anymore, but I had a case years ago where I had jurors tell me that they would not consider the admissions that plaintiff made in the medical records. And it really hit home that, you know what, I need to ask general questions to see if there's a bias just on general evidentiary stuff, not to say, will you believe what plaintiff said in the records, but would you consider them? And those types of things will occasionally pull out potential jurors. The alternate is that it also lets the veneer panel know they're supposed to consider it. So I would say that is something you want to consider as well, on either side, to be honest with you. I just think it allows the jury to at least go, okay, I kind of got a feel for the case. Would I consider that, or is that a soft spot for me?
And the corollary to that on the plaintiff side is you need to ask them, will they consider a verdict in the range of X amount of money for your client if you're able to support that verdict? Because if you don't ask that question, and again, this is debatable, and this whole thing isn't we could do a whole presentation on voir dire, but you don't want to end up getting a low verdict because you never asked the question, because someone said, listen, no matter what, I don't care. I can't give you $1 million verdict. It's not going to be able to do that. I had a voir dire where I asked that in a case where I got a $113 million verdict, and I asked everybody at that, and everybody's arms were crossed like this. And then the person asked me, and I had to, and then then the response was, this is not for any pain and suffering damages. This is only for documented wage loss. And then everybody's hands went down like this, and everybody was like, okay. And I got a commitment. Just like when John says, are you guys going to consider medical admissions that the plaintiff injured himself playing softball? It's 3 times in the records. Will you consider that? And you are telling him that, and you're highlighting the main parts of the case.
And let me bounce back off of that real quick, Gary. Let me bounce back off of that. Also, I will say, I actually have no problem with plaintiffs' attorneys going into, do you have a problem giving big verdicts? Because in my voir dire, I address the elephant in the room, which is, For example, the 113 million, who thinks 113 million is chump change? All right. I think it's important for the defense attorneys to not let that sit. It's very important for us to be asking questions like, the U.S. government spends billions and billions of dollars that they're giving to Ukraine, for example. You can throw out any example, but how does that? Do you see that every day? Yes. Do you kind of get numb to those numbers? And you'll get people go, yeah, yeah, yeah. Like, what if somebody offered you $1 million out of the blue? Would you go, nah, that's not enough, man? I mean, $1 million, that's just chump change. So I think it's incumbent upon the defense attorneys to counter the strategy that Gary uses, because we have to be able to suggest to them that the money he's asking for is a significant amount, and it's not their choice to just spend somebody else's money. I know we're probably at the
great way to this. And then and on liability, if I talk about liability, I've seen good defense lawyers say, do you guys realize at the end of this case, you can say no one's liable? It's sad what happened here to this man, but there's times when sometimes stuff happens in life and no one's at fault. And I find that to be deadly effective against me. I've had lawyers use that. I'm not saying I lost or anything. I mean, it is what it is, but I think that's a corollary to that too. John, anything else? John,
those are just some key points. And I would say, get in and out as an attorney on voir dire. Whatever you know your case, you know what you're going to try, you know the evidence you're going to put in. Just do not go overboard. And I've had plaintiffs' attorneys go, if you could go one place in your life, where would it be? And it's just like, you know what? And they all answer the question. And I get up on voir dire and I said, that question had nothing to do with the case and nothing to do with what you're going to deliberate. It was simply a question to kind of get you to like the plaintiff's attorney. Do you guys, are you phased?
Where do you get your news? I asked the guy back row one time. I said, he was standing up. I was talking. I go, where do you get your news? And without missing a beat, he said, why? Do you want to know if I'm conservative? And I'm like, exactly. Well, I thought, hey, John, we have John Pulaski asks, how do you get in the chat? How do you get the time? This goes to your point you're making, John. How do you get the time to ask all these questions during voir dire? Every case I have, the judge makes you rush through voir dire. That's true. Now, on the plaintiff, if I could start answering first, John, because the plaintiff is more hamstrung to begin with, and you want to know right away what that you need to do that before you walk in. What is the judge going to do? What they're not going to do? Genevieve, from my office has tried a couple cases in Illinois most recently, and over there, these judges are doing a lot of these questions, and then they hand it over to you for the meat and potatoes. Federal court is different. I was about to try a case in St. Francis County earlier this year, I took it to the judge. What can I do and what I can't do? And so, John, so you need to have your short voir dire. If my voir dire is only 20 minutes or a half hour, what's the key stuff that I want to say? And maybe that should inform you what you should do in the first instance. But anyway, John, go ahead.
I absolutely concur, Gary. That's absolutely right. You got to know the judge. So far, in the last, since we opened back up, the judges are not giving me time limitations on voir dire. I'll be honest with you. Now, again, I don't take that long. The questions that I'm talking to you about, they fly through. It's not like it takes a long time, because strategically, if you're a good lawyer, the questions you will ask will initially pin them down anyway. You're narrowing the focus of your questions anyway to relevant issues. So you're going to get to the heart of their position pretty quickly. So I have not found that time is an issue for me. I still find that 45 minutes to an hour for me on voir dire, I get it done in that time frame, and it's not really a problem.
Before we, anything you want to leave anybody? I have a couple things on voir dire before we leave. Anything you want to do that before we move to opening?
Nope, you roll.
Folks, in every case, I file a jury selection memo. But what I always have whenever I have my voir dire, I have two things. I have my list of questions and how I cement a juror for cause. when I get them going on something where I think I can get them, I have a list of questions in the back that I pull out. It's an order that I do it about how much they believe in that, and they believed in this all their life, and that's not going to change in 3 days when they're deliberating, because you want to cement it. Because remember, John's going to get up and say, hey, can you be fair and impartial? Can you follow the judge's instructions? And they're going to say yes, because if you ever ask anybody if they're going to be fair, they're going to say yes. So I have that. And then the other thing I find is you got to be careful with your own stereotypes, folks. Just because someone is a race, or just because someone is a manager in a company, or just because somebody is something, doesn't mean that they're for you or against you. You need a deeper look into that person and a discussion, and you need to listen. So I find myself, I still, and I know that lesson, and I know it in myself. And we just had the great presentation by Jasmine about listening, but you got to be careful about that. John, I saw you nodding. What's your experience with that?
Well, the case I just tried, nurses are generally not favorable to the defense, right? I actually do not like nurses because you don't know what you're going to get. Well, my client just happened to be a nurse. So I had 3 nurses on my jury, and they went with what I suggested as the verdict. So it goes to the point that you're talking about. The stereotypes sometimes don't work. You got to figure out, could this person work for me? So I completely concur with what you're talking about. And by the way, I would also say on the defense side, if your whole strategy after plaintiff gets prejudice some potential jurors is, could you read the jury instructions? Could you be fair? You fail. You'll never, ever get that juror to be reconsidered. You got to go much deeper. You got to say, what if the jury instructions say that that you have to treat each party fairly, because that's essentially what they say. You got to dig a lot deeper. You probably, if Gary does his job, you're never going to get that person back anyway. But asking those 2 questions, could you follow the jury instructions? Could you be fair? No judge worth their weight in gold will ever say that's sufficient. You sadly aren't making a record for appeal.
The second thing I do is I have that statute. The Missouri statute on jury selection is very powerful, very short, very tight. I always have that with me when I'm arguing strikes for cause, and I hand it to the judge, and I say, and it's very strong language, they cannot have formed an opinion as to any of the matters at issue in the case before this. So have that too. All right. Thank you, John. Would you share some of your thoughts on opening statement, please?
Yeah. So this is happening more and more to defense, and it'd be funny. I haven't done it yet, but I might start doing it to the plaintiff's attorneys just for a little fun. But I'm having some attorneys copy my on my opening statement. They'll have it transcribed and have it there for closing. Why is that important? Because we often say a lot of things in opening, and this goes for plaintiffs and defendants too. We start to filter out the distinction between what we believe the facts will show and the evidence will show, and we get into argument. And it's a natural thing, right, Gary? It's like the case is rolling, it's time to roll, and you start saying things that may not be 100% accurate. And you have got to be careful.
I have never done that. I don't know what you're talking about.
Yeah, it's never happened to me. You had to be very careful in opening. That doesn't mean you can't project strength on your case, plaintiff or defense attorney. There's nothing wrong with saying, this is what the evidence will show. And I never even say this is what the evidence will show. I'm so past that, the evidence will show you this, the evidence will show you that. That's boring. But you talk about your case, but you have to be careful. Because when you get into argument and something isn't proven in the case, even though opening statement is not evidence, you'll get pounded by the plaintiff's attorney. And I promise you that the plaintiff's attorney will make closing argument about you as the attorney. You can't be trusted. You're not honest. You told them up front to try and prejudice them. And this is how it went down. So be very careful. Stick to what you know is in the case. Stick to what you know the evidence is, and don't push the envelope until the evidence comes out, and then you can argue the reasonable inferences in closing. Then you can argue what ultimately came out. And here's the other thing I would recommend. You don't have to engage in word salad in opening and tell the plaintiff's attorney everything you have. I know in today's practice, there really aren't any surprises, but sometimes there still are. So you don't have to tell the jury everything in your case. It will come out, and if you can, save some surprises. And that goes for both plaintiff and defense, Gary.
One of the things I like about that I appreciate with talking trial with John is, I mean, John and I never do. We don't talk about trial, really, frankly. And one of the things that's fun is to see someone else in the trenches practicing that ends up learning the same lessons you have learned through your own experience. Because everything John's saying is stuff that I've learned too. When I first started, you were supposed to win your case in opening statement. They'd say, if you got to win in voir dire, and if you haven't won in voir dire, you better win it in opening. And now I'm the opposite now. I think it is more effective and I wrote this in this, I wrote number C and D after John did A and B on this slide 6 here. It's, you got to under promise and overperform. There is nothing more powerful than if John doesn't say everything in opening statement, then when he's putting their case on, the jury's going, wait a minute, he didn't even tell me that in opening. Wait a minute, it gets better. And when I'm doing opening, because you want that jury to reach their own conclusions. You want them, if you're forcing, just like if anybody tells me what to do, I'm going to do the opposite. Right? And juries are like that. So you want to lead them down that path, but it's so much more powerful if there's stakeholders in it, if they followed you and if they've made those conclusions. So as a plaintiff, I like to underpromise. And then during the trial, I want them to be going, wow, they got that. How did they get that admission? How did they get that admission? And so by the time I'm done, I'm getting credibility, because when I walk in as a plaintiff's lawyer, maybe any lawyer these days, right? The lawyer, they think I'm a liar, right? Lawyer, liar, right? So I want to underpromise and overperform. And then you do want to be intentional in your opening and respect them. Don't pander them. Don't be disingenuous. Some of the lessons that John was talking about in terms of credibility and voir dire, they hold throughout the whole trial, and especially in opening as well. You don't want to throw in everything in the kitchen sink. You don't want to make big sweeping statements and blah, blah, blah either. And I'll tell you, I do, when John was talking about his opening, one of the things I do, so if not John, but if a different defense lawyer said too much at opening, in my first witness is usually my client. In my plaintiff on the stand, I literally have a section almost every time where I say, did you listen to opening statement? Yes, I did. Did you hear him say this? Yes. Is that true? No. And then they tell me why it isn't true, and I show the photographs or the medical or blah, blah, blah. And then I say, how'd you make that feel to hear that, to hear yourself talked about like that? And they talk about that a lot. So being an and John, and then as defense lawyer, you don't need to do it, because you're giving ammo. You're getting whether you're ordering the transcript or not, but you're using that. Remember, you're using that. And in closing, every time I say, remember when Mr. Rahoy promised he'd show you this, and where is that? So there you go. Be intentional, be direct.
Oh, and on the plaintiff side, I would tell you, follow up real quick. I had a case. I've had attorneys go really deep into the sympathy aspect immediately in opening. And all it does is open the door for me to say, and I'll do this just so you know, so don't do it when you try a case with me, but I'll have my cell phone and I will just start my clock. And I'll time how long they talk before they get to the meat of the case. And I'll say that was 6 minutes, 10 minutes spent on sympathy, ladies and gentlemen, nothing about the case. That tells you all you need to know. Now let's get to the facts. So the flip side is true. Gary is 100% right. That doesn't need to be done. The storytelling will come through your witness if you got a great witness. The storytelling will come through the exhibits. And then in closing, then a good attorney like Gary will wrap it all up into a beautiful bow. And that's where the sympathy comes in. That's where you are able to make connections. So just another thing there.
And let me dovetail on what John said. You don't want, if you're a baseball team, you don't want to, no, jokes about the Cardinals being in the cellar aside right now, but you don't want to peak. You don't, a baseball team doesn't peak in June, July, and August. A baseball team peaks in September. And in your trial, you need to peak at the end of your witness. You need to peak and close. And you don't want to lead off with sympathy, because if someone comes into your office and starts saying, feel sorry for me, I mean, you're wearing that on your sleeve. It doesn't work. And remember what John said in voir dire, and we talked about it a little bit, but John is already going to have hammered sympathy in voir dire. And you got to read the room, because then you're getting up and doing an opening when he just got everybody to say that's not about sympathy. And in my voir dire, I usually say, we don't want your sympathy. I know John, good lawyers like John are going to do that. So I try to take the wind out of his sails, and I say, we don't want your sympathy. Sympathy's fine. There's nothing wrong with it. But here we're about the facts of the evidence. And I say that, and I kind of move on. I frankly, I do want their sympathy. So it's a little distant, right? I mean, I do, but I don't. I want evidence-based sympathy and not just sympathy for sympathy's sake. They're not ready for that yet. The flower blooms when the flower is ready. Anything else on opening, John?
No, I think that's it.
John, why don't we go to, can we talk a little bit about, so part of our presentation, folks, was about how tort reform and how has tort reform weathered the test of time. So before we get into closing statement and other parts of trial, I thought we'd talk a little bit about bill versus pay and experts. John, in my experience, and I'll go first on this one, and then hand it to you if that's okay. Bill versus paid I don't find it anymore. I don't have a battle about it anymore. It is what it is. And 99% of the lawyers that I work with on the defense bar, I get along with most of them, because most of them are pros when you're going to trial. And most of them, we get together and we get our paralegals together and we figure out what the billed medical is, what the paid and the owed medical is, and we do a stipulation. So rather than having a hearing in front of the judge, which you can have under the statute, I have never had one of those hearings. I mean, I did it before the statute, when DEC was still at issue. We did a lot of these depots of what's the reasonable value of medical, blah, 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 and doing all this. But I haven't had a battle about this in years, because it is what it is.
That's right. I agree with that. And it's not worth it. It's painstaking. And yes, the defense attorney gets paid for it, but it's just not worth getting into the battle. The numbers are the numbers. The jury can decide, and you're 100% correct on that. It's a waste of energy and your client's money on the defense side if you can reach an agreement.
But in terms of the lasting effect of it, I think it's been effective. I mean, effective in tort reform. I think it has decreased, certainly decreased medical expense valuations that you can put in. Everybody was bucking at it and fighting it and all that stuff, but now it kind of is what it is, right?
That's right. I agree.
100%. John, do you find more people? Do you find plaintiffs' attorneys effectively not putting in medical and getting big verdicts, or is that a mixed bag?
I think it has to do with the case. I think, obviously, on a traumatic case where the person is paralyzed, or you truly have brain injury or leg off cases, those types of things, I don't think doing the pain and suffering argument to the jury and not putting the medical in is relevant. A wrongful death case, you're not going to have a ton of medical in a wrongful death case, right? So necessarily, right? They may die at the scene. So I think, as we've been talking, it's a gray issue. I think plaintiffs' attorneys in non-traumatic cases make a big mistake in not putting medical in. I think, again, I don't want to get into all my strategies, but I think the pain and suffering aspect of it, if you handle voir dire correctly on the defense side, to address pain and suffering and use the instructions and then talk about it in the evidence, and undermine it. I think it actually doesn't help the plaintiff's attorneys. I know there's a big push to try almost every case without medical bills. I just don't think that's that effective in many cases. I think it actually hurts the plaintiff's attorney. That's my opinion.
Have you had it successfully done to you where medical's not put in and they still get a verdict that would have been higher had they not anchored to a lower number, which is the rationale behind it?
Yeah, I have to tell you, the last 2 trials I've had, the medical bills weren't put in. They went pain and suffering. One case, I got 80% on plaintiff, and they gave the very number I offered. The second one, the attorney asked for $5 million, and I told the jury $250, and I used the instructions to suggest that there was no evidence of substantial evidence, right? Of pain and suffering, and they gave the number I suggested. So
what if lawyers aren't as good as you?
I would say on the defense side, well, mine is from experience. It's not so much that I'm so good. It's just that I've been there, done that 1,000 times. And defense attorneys need to be creative. They need to understand that the amorphous kind of malleable pain and suffering needs to be addressed. It's got to be addressed in voir dire. It's got to be addressed in opening. It's got to be addressed with witnesses. And then again, you got to wrap it up in closing. If you're not capable of doing that, if you are someone that is inexperienced, I would agree with you, Gary. You're going to get your butt handed to you. But I know that some attorneys do not like when plaintiffs do that. I just am not of that ilk. I don't believe that it's a problem. I think it's becoming a bigger problem for plaintiffs. And I teach all of the attorneys that work under me that very thing, is that you have to attack that. You have a lot of avenues to attack it. You have a lot of things you can do. And, but if you're not capable or you don't feel comfortable with it, you're going to be in big trouble.
John, I don't really disagree. I consider it in every case. We talk about it, we weigh it. I tell you, and I've done this before too, a bunch of times. I've had some cases where I've gotten verdicts. I go, thank God I put the medical in, because otherwise I wouldn't have anything. But and you really have to balance how much are you going to anchor low with the low medical number versus the other risks inherent into it, because you're not putting up much of a case. And then there's a lot that you got to be real careful doing it. And it takes the right case. I mean, if you have a brain injured person or some real traumatic case where it's where the medical is just not going to reflect the true injury, I see it. But some of these cases where it's done, I just don't see how. I think it's just really tough to do. It's like using you got to really look at the facts of the case to make sure it applies in your case. And I think too many plaintiffs lawyers are doing this in like a cookie cutter way. And I happen to be a reptile guy, and I've been for a long time. And you can say, what's reptile, right? But people sometimes think you can sprinkle reptile dust or whatever the latest trial tricks are. Ask for a big number. Everybody go in and ask for $10 million a trial, and you're going to get it or get a fraction of that. I don't think that works. And so we're very intentional with the cases where we do it. I frankly haven't done it. I haven't. Maybe other people are better lawyers than me, but because I think you can sit there and you can say, hey, jury, I know the medical here is only 20 grand, but I don't want you to anchor that, because the real case is about the fact that he's got a herniated disc and is going to limp for the next 50 years. And that's what this case is about. And jurors get that. I mean, I don't know. Yeah. We can debate that.
We can go back and forth all the time on that. That's true.
John, can we move to we talked a little bit about with the Court of Appeals judge, with the judges on expert disclosures. How successful have you been in coming in and either striking experts or then this is pre-trial. This is all, remember folks, that we switched to Daubert, either striking experts entirely or limiting or constraining their opinions.
I would agree with Judge May. It's more of a limiting. Although I have to tell you, you know, Daubert isn't the standard. It's Rule 702 now. And Daubert was based on the old statute. So I never argue Daubert. I argue 702. And the 702 has language that Daubert does not. Daubert had language that's the new 702 does, and you're not allowed to use the Daubert standard in some parts. So you remember the question I asked of the judges, are they following 702 amendment? That's the reason why, because the amendment says specifically, I'll get here in a sec. It says that in order to have testimony of an expert witness, the expert's opinion reflects a reliable application of the principles and methods, not just can it be reasonably relied on. Some would say that's a distinction without a difference, but it isn't.
It is
much more.
Not.
It is very specific that the expert's opinion is reliable on the principles and methods, not just some opinion that gets in. So I don't take issue with you talking about Daubert and expert disclosures, but I never use Daubert anymore. I don't bring the case. I don't argue it. And I tell the court, it's 702. Setting aside the what Judge Gardner said about what the Eighth Circuit is doing.
Yeah, and I'm sorry, you're right. And I talk about Daubert. I had another version of this where I had edited that out. I go to the statute, and I guess you don't see it on this slide. But if you're arguing those folks, you're getting it ready to get that statute and look at exactly what those requirements are. And you ought to be thinking about that when if you're taking video depots for trial. You got to get that right in that video depot. You got to be doing it then. Are you able to, what about in treating physicians, John? Are you able to, one of the things I do, if I'm using my treaters to bring in, what I'm worried about when I'm bringing a treater in is that, are they going to really be able to talk about all the other records and the other causation, and they're going to talk about prognosis and stuff? So what I do, because remember, your experts have to have all the facts of the case, and you can't just have their own records. And if they don't have the ER record, or they don't have the MRI from 4 years before, I think you have they may get struck, or they may be really limited, and they're also not going to be very happy about it either if they don't have that stuff. So in my disclosure, my initial disclosure, it tells John, if I'm disclosing an expert, I say, I'm going to name this treater, but I'm also going to give him a bunch of other records. And here's what I give him. I'm going to have him talk about causation, prognosis, diagnosis, future medical, whatever I'm having, and connect it all up. Because if you don't give that, and if you don't give it to him, John's going to kill him on cross too. What's been your experience with that, Scott?
Well, clearly on cross, that's easy fodder, right? I mean, a plaintiff's attorney that doesn't produce all the records and handpicks the records, you're just going to get hammered. That's just silly. You shouldn't do it. It gets back to what Gary and I were talking about in opening and voir dire and credibility. You lose all credibility. I don't know why you would do it. It's one thing if the plaintiff hasn't told you about some medical records and you find them on the defense side. That's a whole different story. So I agree with you. I have not had the situation where the expert was stricken because they didn't have all the records, because in that instance, I would say, look, if you have an orthopedic surgeon who does surgery all the time, that is his opinion or her opinion that someone needs surgery reliable and based on sound evidence? Well, yes, because his opinion can disagree with somebody else's. So I would argue that it's much tougher to strike an expert just because they don't have all the records, but I think it's stupid not to give them all.
Great. John, we're winding down on our time. Why don't we talk a little bit about closing argument? If we'll close with closing argument. Folks, I put in slide 9, and these are all we have a lot of the law about what you can't say. John, you want to talk about you added some stuff about what you can say. Do you want to talk? I really like some of your points. You want to talk a little bit about that?
Yeah. So if you go to the bottom here, look, one of the things that is true, you can't, talk about a witness who doesn't testify, but in with physicians, you are allowed to talk about the treaters that, didn't testify, that, Gary wouldn't do this, but unless he had to, but you go get an IME and, so you bypass all of the treaters, and where are they? I think that is absolutely admissible. And it's proper to talk about the falsity of statements. It's not a prejudicial thing. You're more than fair to create slides and saying plaintiff was false here. Obviously, this is old, tried and true. You don't accuse somebody of being a liar, but that their statements are false either in the records or about the incident.
John, is that how you try to say that in close? What do you say? Why don't you say liar?
Well, because
pejorative?
Sure, it's aggressive. If you have the evidence that shows that what they did was or what they said was untrue, you don't have to pound on them. You don't have to beat them down. Now, if you've got a guy that's been in prison and he's got multiple cases of prior thefts and criminal convictions, okay. I mean, there are certain times where you can cross the line and go, he's a liar. He always has been his whole life. And, here are all his convictions to prove it, right? But as a general rule, a jury doesn't like attorneys attacking the other side. And that goes for attorneys too. The juries don't like the attorneys attacking one another either. So I never call them a liar. It's proper to call out the exaggerations. It's proper to discuss the evidence and use demonstratives. I am heavy in my closing on demonstrative evidence and the actual evidence. And I use that as a roadmap. So
John, I'll let you keep going. Do you show your demonstratives to the plaintiff's lawyer before you get up?
Always. In fact, yeah, I mean, you must. I think it is, you don't have to show before closing because you don't want them to, know what you're going to say. But I think it's proper to say, here's what I'm going to use. I'm using exhibits, 10, 12, 18, whatever. I think that's proper. I think that's professional, right? When I do
I've had this where they get up and they start to pull up a blown up document. It's a demonstrative, and I'm like, I've never seen this before in this whole trial. You got to show, and then that's gonna slow things down. And then you go to a sidebar. This is not fair. Show the other side what you're doing before you do it. Not like 2 days before, but show it to the other side. That's professional courtesy, and I think that's a basic due process requirement in trials. Sorry, John, go ahead.
Nope, totally agree. I'll even go so far, and if I'm doing a PowerPoint presentation for my opening, I'll print out the slides and give them to the plaintiff's attorney to review. Now I have had occasions where, it happened at the last minute and I felt bad. It wasn't intentional. It was one of those things. I'm about ready to do it. And we haven't even started opening, but we're about to. And the poor attorney, is trying to flip through them. You don't want to do that. That happened in a case, and I felt pretty bad about it, not because it was intentional, just because I should have given him a little more time. So shame on me for that. But I even do that for the PowerPoint for opening.
It's so smart, because what if you got something wrong too? I've had it where I'm about to do something. The defense lawyer goes, hey, listen, this is wrong. You took this from here. I'm like, oh yeah, man. Oh, sorry, dude. And I pull it out because, so there you go. And do you, John, do you highlight this promises made in voir dire and opening? And
yes.
And how do you do that effectively?
I don't do, sometimes I'll say promises made, promises kept. Sometimes, but most of the time I said, I said, look, here's what I told you. And in order for me to have credibility, I made sure that what I told you was in the evidence. So one, that eliminates any argument by the plaintiff's attorney in the last 10 minutes of the closing to, go out at me. The other thing that I think is very wise for defense attorneys, I had a case recently where one portion of the injury was clearly related. So I stated in opening statement, you're going to find that the injury was caused by this incident, but that doesn't mean that my client caused the injury. And then I said, however, the other stuff that they're claiming, we're going to have a big fight about. So in closing, I said, look, I told you I couldn't have credibility before you if I didn't tell you that the actual, and it was a thoracic outlet injury, the thoracic outlet is related. It's clear it's related. And I have to be an honest broker with you. But, and then I go on. So it's the same kind of thing, promises made, promises kept, whatever. But it's kind of the same theme, is that by doing that, the jury sees that you're credible.
One of the errors that I see, you pointed out things that plaintiffs lawyers, one of the things that I think defense lawyers do wrong is they have a throw everything against the wall and see what sticks attitude. And that runs counter to your points about credibility, because they'll say 10 things and maybe 5 of them are true. And I think that underscores them. I think that a more effective defense lawyer is to have that theory. It's not just a plaintiff's lawyer that's got to have the theory of the case that's uniform throughout. I think the defense lawyer should too. And to
Absolutely.
And do you see that as well?
Yes, absolutely. If you're not going to streamline your case on the issues that matter, they're going to get lost in the case. So you're 100% correct. The whole shotgun approach, 1, it's not effective. 2, it allows the plaintiff's attorney to go ahead and say, well, look at all these things that he said that never came to pass. That's just, you can't believe what Mr. Rahoy says. Look, I look at it this way. Setting trial aside, in any of your daily relationships, what's most important? Your credibility, your integrity, your honesty. And so if you can't, even when you do something wrong, having integrity and telling the court you're wrong and you made a mistake, all of that is important. So if that's how you want to live your life in the real world, why would you not carry that before 12 people that don't even know you?
Great point. And one of the, John and I are both blessed that John's father and my mother were in law. And I know, John, you learned a lot from your dad trying cases. And I'm sure that's one lesson you just said is one lesson I'm guessing you learned from him, right?
That's correct.
and I've learned a lot from my mom too. I have one question for you, but any questions for me or anything else before we close this down?
No, you've done a really good job with this. Even, except for that first picture.
That's my question to you is, why did your dad let you wear that, dude? Let's bring it back to the jeans. And is this coming back? I mean, the stonewash, that's such a classic look.
Here's what I've got. First of all, we just talked about showing, it's just due process and common courtesy to show people what you're going to present. And you did not show this to me. So you
have a couple tricks.
You violated the very tenet upon which you stand for. But I have no explanation for that pathetic outfit, to be honest.
All right. Well, that's all I got for this one. Hey, John, thanks for your friendship and thanks for doing this. You're a great lawyer, and I appreciate practicing. I appreciate you being in the bar with me. Thank you, sir.
Same to you, brother.